Hey folks, how y'all doing?
Good. How are you, Nick?
Doing all right. All right. So I'm using these headphones. I don't know if they work. Give me a thumbs up, Dale, if you can hear me. All right. Hey, how about that? Good. Good to know. Thank you. So we still got about 5 minutes. So everyone feel free to do what you want to do, mingle. I'm going to start probably around 3:03, 3 or 4. Maybe some later arrivers, and I want to make sure that we are able to get everyone in here who needs to do some learning. And I'm not sure how a lot of you are going to be like if what sort of access that y'all have to the new contract. What I'm going to do is if you don't have it readily accessible, then I'm going to post a link to it in the chat. And I'm also going to be just kind of following along with the changes. The one I have is the one that's marked up with the changes that were proposed and that are being put in place. So I'm going to post a link to the chat around 3:03, 3:04, so that can be accessible for those who need it. All right, so it's 3 o'clock. I'm going to give probably a couple more minutes for everybody to get here, and then we will get started. I don't know what Zoom etiquette is these days. I try to avoid this as best I can. This one was unfortunately thrust upon me by our current construction situation, but it is good because I'll be able to record it. So make sure the questions that you ask are very intelligible and smart and impress everybody who's going to watch this later. I'm just kidding. I can't see anyone's responses because everyone's learned that you don't have to be on video for this, so it's nice. Thank you, Melissa. I appreciate that. Except Dale. Dale's taking the challenge, so I had to use Dale helped me out with he was able to give me a visual reaction of whether my new headphones were working or not. So we're holding strong together. All right, so it is 3:02. So we've given a few minutes for folks to get here. So I'm going to go ahead and get started. For those of, I think I've met most of you, but for those who I haven't met, I'm Nick Lovelace. I am one of the attorneys with NIP Law Office, and I manage the office here in Kannapolis, right next to the Lantern office in Kannapolis. I also manage our Concord office down across from Concord Mills, and I am fortunate enough to be teaching you about the new contract today, kind of these changes that have come into place. And please stop me, ask me any questions you can. Feel free to unmute, ask me a question. I am here to help you. I'm here to notify you. I'm here to inform you because there are a few substantial changes from what you're dealing with in 2020 versus what you're dealing with in 2021. Now, before we get started, just want to let y'all know it is the preferred practice to, now that the 2021 contract has been released, it is the appropriate practice to use the 2021 contracts in any contracts that you're doing going forward. So if you're going to, I mean, that's the ideal. So even if you want to keep that 14 days in place, whatever's in the contract, that's what you have to go by. So if you happen to use the 2020 contract, it's not the end of the world. It's not a deal breaker, but you are going to be bound by the contract that you sign. So it happens every year. In July, we start getting contracts. Last year, we got 19 contracts and 20 contracts. And it's going to happen. It's kind of the nature of sending out a new contract and changing the contract every year. So that's going to happen. And but it's best practice to use the new contract now that the new contract is out. So without that being said, I'm going to go ahead and share my screen, and we're going to start working on the new offer to purchase slideshow that I've got to keep getting together. So I'm going to go ahead and share that. Everybody should be able to see that at this point. I'm going to go ahead and get the slideshow in place. All right. So if somebody can just let me know that they see Dale, give me a thumbs up if you can see the screen that I got. Perfect, that's all I can see. I appreciate that. And so we are gonna go ahead and get started. So this is my presentation on the 2021 North Carolina offer to purchase contract changes. Your standard 2T documents, a lot of these are gonna carry over to the 12T for vacant land as well. Some of these won't, but you can read through that. But it's going to be, if it changes in one, it usually changes in the other. I'm not going to focus on anything commercial in nature these days. Our firm is primarily a residential firm, so that is what I'm focusing on today. So if you have any commercial questions, you can ask me. I may have to refer you to somebody else either within or outside of our firm to answer those. But getting started, and please stop me, ask questions as we go through this. There are some things that are going to be considerably different, even though they might not seem so. So every year, North Carolina Association of Realtors and the State Bar gets together to work on what changes are needed to the contract. They take into account basically complaints that they get. They just review everything. They look at the technology that's available in the time. They look at the state of the market. They look at the state of real estate and issues that have been happening over the course of the last few months. And so that's why every July you get to learn about these changes to your favorite document that gets you under contract, or at least that you submit a bunch of, and eventually, hopefully, get one accepted. And yeah, the more changes that happen, they're really a good thing. I mean, it's frustrating to have to basically relearn some aspects of the contract every year, but it's a good thing because it is helping the industry keep up with the times as opposed to falling behind. So what causes these changes? As I said before, changes in the industry. If you see things happening in the industry that, I mean, obviously the evolution of iBuyers, the evolution of electronic payments, the way that people have managed the way that people are managing properties, the way that people are doing things causes these first changes in the contract. Agent suggestions, if enough agents see something that's causing them an issue, then they'll refer that to your NCAR, and NCAR may actually take these into account. Like I said, third, just keeping up with the times, making sure that everybody understands what's kind of how the industry has grown, how the industry and how the markets worked, and how we can make sure that the contract keeps up with that. So, and before I go any further, one thing I do want to do is I'm going to again paste in the chat a copy of the marked up contract. So if you don't have the 2021 contract in front of you, you can refer to this in order to look through those changes as we get to them. So I've just posted that in the chat again. So if you need it, there it is. There's a link to it. All right, so your first change is going to be located on paragraph 1D, right on that first page. And what that is your basically how you can pay due diligence. And that change basically requires more specification on how the due diligence fee is paid. Why? So it kind of lists all those different ways. So now it can be paid by mail, it can be paid by phone, it can be paid electronically. So it's kind of that's the big change is you can, as long as a seller signs off that they've received due diligence, your lender may care, but the attorney's we're not going to care because we never see it. And other folks aren't going to care. Basically, as long as that money goes from the account it's supposed to go to the account to the seller, then it doesn't matter. So you can pay if you want to use Venmo, if you want to use Zelle, if you want to use your cryptocurrency, whatever you want to do, you can, if the seller is okay receiving cryptocurrency or Bitcoin or all that other stuff, then Dogecoin, whatever the exciting stuff is these days, you can use that as long as the seller signs off. Now, that being said, your lender may not be okay with that. So if you're dealing with a loan, you might want to just advise, hey, let's just give them a check or something like that, or even, but Venmo and Zelle are two things that are generally going to be acceptable also. And it also lists down at the bottom, any electronic transfer fees the cost of those will be borne by the buyer. So if the buyer wants to use an electronic transfer, then the buyer needs to pay for the electronic transfer. Likewise, the seller agrees to cooperate by providing the appropriate account information in order to accept. So if the buyer sends in a contract saying, yeah, I'm going to send you due diligence by electronic means, the seller, by accepting that contract, is also agreeing to cooperate by providing the account information that they can use to deposit. So the effect on an agent's daily life, which is kind of the one thing that matters the most to you, because how the contract change is going to affect you, should be relatively minimal, but you might want to advise your client if you have a buyer to verify with your lender that it would be no issue to use one of these electronic payment methods to transfer the due diligence over from from the buyer over to the seller. Any questions, thoughts on that? Anything? It's pretty minor, but it's good because it gives more options to again, growing and changing with the times, things like that. All right, so if everyone is good with that, we're going to go ahead and move on to change number 2. And that is, if I can get my fingers to work here, there we go. So it no longer says, and this is also paragraph 1D, it says that the EMD acceptance is no longer supposed to be sent, quote unquote, with this offer. Now the EMD is supposed to be sent by the effective date of the contract. Why is that? Because you shouldn't be expected to pay EMD until you have an accepted offer. It's pretty much not real. I mean, it's more of a cleanup change, but I did want to make y'all aware. I mean, the expectation isn't that you send in EMD as soon as you send an offer in. That makes no sense. So the language didn't make any sense. Now, by the effective date of the contract, which is when the seller signs the offer of the buyer, that's when the beginning period to send EMD over to whoever the escrow agent is going to be comes into effect. So whether that's us, whether that's whoever that is, whether that's another attorney, that's the point at which you should send EMD over. Don't send EMD with an offer. Obviously, that doesn't make any sense because you don't have an accepted offer at that point. I'd imagine none of you are actually doing that, but in case you are, then you don't need to do that anymore. You can just send it along once the contract is in effect. Any questions about that? And speak up if you have questions because I cannot see everyone on my screen, please. All right. Change number 3. So this verifies remedies in case of non-payment of due diligence and earnest money. So this is a change that I think is kind of important. This now very clearly states, and this is located both on paragraphs 1D as well as paragraph 4G of your due diligence addendum. And so this very clearly states that if you've got a fully executed contract, so buyer has signed a contract, seller has accepted that contract by signing it as well, you have a valid contract, and the buyer afterwards does not send the due diligence fee over to the seller and doesn't send the EMD over to the escrow agent. That means that is a breach, and the buyer is responsible for, if the contract is terminated, for sending those funds to. They're responsible for paying both earnest money and due diligence to the buyer or to the seller as a result of that breach. So I get a property under contract, and instantly the buyer goes, oh gosh, no, I didn't want to do that. I didn't want to do that. I'm just not going to send those funds. You're not allowed to do that. As soon as you have an accepted offer, legally speaking, the due diligence is due to the seller, the earnest money is due to the buyer. There have been complaints about buyers who just have considered, well, I'm just not going to send my due diligence, and that's going to be considered a terminate. That's going to be my termination, and then I'm not out the money for due diligence. Well, now this contract explicitly states that if the due diligence is not delivered, if the earnest money is not delivered, that is a breach. So I always say it's better to deliver the due diligence and then terminate the contract than risk the breach and lose both due diligence and earnest money. Because if at any point, even before the end of the due diligence period, if the buyer breaches the contract, that is considered a breach, and the seller is therefore due both the earnest money and the due diligence. So it's really right now you've got huge due diligence fees, and I understand that because that's just the nature of the market. But at some point, that's going to turn back around, and those due diligence fees are going to kind of normalize. Hopefully, they don't settle at these absurd prices you're seeing them at now. But then once that happens, then earnest money becoming due prior to the end of due diligence as a result of the buyer breach is going to be a big deal. And it still would be a big, it still could be a big deal now. I mean, that's money that the buyer could have in their pocket that they won't. So just wanted to make y'all aware of that one. That is a bigger clarification now and a bigger deal than because I think that's been happening over the past couple of years with due diligence. Any questions about that? All right. So the next one we're going to go through is change number 4. This is on paragraph 1E of the contract. That's on page 2. It just adds the word promptly. So I don't believe Lantern is acting as an escrow agent on many transactions. If they are, then the escrow agent must deposit funds promptly. So if for whatever reason Lantern does act as an escrow agent on a transaction, those funds need to be deposited within 3 days. This was made mostly because there were brokerages and attorneys who were waiting weeks to deposit people's earnest money checks, which, it's not a great look because people are expecting those funds to come out of their account and they're not. And that is stress that is put on the buyer because, hey, that's supposed to come out of your account. It could affect lending issues. It could affect questions on funds and things like that. So if you're, I'm sure most of y'all are not, I'm sure Lantern is not escrowing funds. I'm pretty confident about that. But in case you use Lantern as an escrow agent, make sure that those get deposited as quickly as you can. Any questions about any of that? Perfect. All right, change number 5. This has to do with special assessments. This one could potentially be a big deal. This is located all over the contract. And what it does is it removes the distinction between proposed special assessments and confirmed special assessments. And it changes to whether assessments are either approved prior to settlement or not approved prior to settlement. I know that I've seen plenty of contracts that say under the special assessment piece, if only seller to pay. I see that all the time. And basically it's just because we don't know at this point whether there's any sort of special assessment in place. The if any seller to pay is now gone. You can't write that in anymore because it's basically a matter of, is the assessment accepted prior to closing? If it's accepted prior to closing, it's the seller's responsibility. If it's accepted after closing, then it's the buyer's responsibility. Makes it a lot clearer. Now, what it also does is that it makes, and I'm going to go ahead and move on to the next page. It makes the investigation into the existence of special assessments a due diligence item. So there have been a lot of complaints about how assessments have been treated as also always a seller paid cost for the most part. So it's potentially more work for the attorney's office because you could start to request resale demands prior to the expiration of your due diligence periods, which, I mean, it can take the HOA quite a long time to get those resales to you. What it's going to mean in more of an actual sense is if you've got a property with an HOA, you're going to go ahead and want to make sure as part of those property disclosures whether there's a seller assessment there. If there's no representation made as to a special assessment, you're going to want to press a little harder. You're going to want to get an idea as to whether there's a special assessment directly from the HOA. Now, if the seller is not cooperating on that, then reach out to the attorney and see if the attorney can get that resale demand prior to the expiration of due diligence, or at least call the HOA and try and get an idea of what that would be. Because again, this is going to be potentially more work for the agents, more work for the attorneys, more work for potentially lenders also. It's just a matter of determining whether that special assessment is being considered, how much that amount's going to be, and because now it's considered an item of due diligence, so it's an item that's not going to affect title, but you can't get out of if there turns out that there is a substantial special assessment that was not disclosed. Does anybody have any questions about the special assessment piece? Because I do think that's going to that's going to be a more substantial change that you're going to run into. All right. So the next one, it's on paragraphs 2B and 3. And it changes the language to basically say that it's personal property that is to be conveyed with a property. So personal property that's included on the contract is to be present. The same personal property is to be present on the property on the date of the offer. And the reason that's included is basically to keep a seller from taking something that all the parties agreed to and then replacing it with a similar item or an item that's potentially not of as high quality. If your seller says that they're going to convey something to the buyer, it needs to be the item that was conveyed, that was agreed to when they went under contract. So if you've got a fridge that you're conveying to a buyer, then you can't take the fridge that you like with you, buy a different fridge and put that fridge there. You're not supposed to do that. Seller's supposed to, if the seller wants to buy a new fridge for themselves, they can do that. They're not supposed to take the fridge from the property and put a new fridge on there. That's not gonna work. So effect on your daily life, just keep your sellers in line. Don't let them take stuff off the property if they've agreed to convey it to the buyer. That is a breach and that can get them in trouble. Anybody have any questions on that piece? All right. So your next one is another one that's been a relatively big change. This is in response to something that the contract had last year, particularly about the down payment assistance box that was checked on there. They were finding that that was potentially discriminatory, or not discriminatory, but potentially prejudiced folks against offers with down payment assistance. So where can that be found? The loan type changes. Paragraph 5A is where that can be found. That's a big, and it's changed pretty substantially. So what you're doing is it actually gives you more room to clarify the sources of your funding. So if you do happen to have a second loan that you're getting, if your buyer is paying down payment assistance, you can write that there on the second mortgage loan, but you're not required to check something saying down payment assistance. Now you're supposed to put it there, but so it's basically giving a little more latitude if you're getting money from a third party or something like that, getting gift funds, something like that, you can list that there as well. Now, there also lists still, if you're intending to get via FHA financing, VA financing, conventional, anything like that, it doesn't remove those. So if your buyer is getting one of those sorts of loans, that number one, best of luck to you in this market. But if they're getting those sorts of loans, then you're going to still want to disclose that, because they have added a line in the note below that section that says material question. I'm going to read this verbatim. Material changes with respect to funding the purchase of the property that affect the terms of the contract are material facts that must be disclosed. So basically what that means is if you have a buyer who suddenly has, for whatever reason, has to change from a conventional loan to an FHA loan or something of that nature, or conventional loan to a USDA loan or something like that, or from one of those back to a conventional, even though people aren't really going to care as much about that. But if they have to do, or from a cash to a lender file, if you're changing funding, you need to advise the seller that you are doing that. You need to advise the seller's agent if you're doing that. If you don't, that is considered a buyer breach to the contract. You risk having the contract terminated. You risk having your buyer considered in breach, and you are then at that point risking their earnest money and risking the contract being terminated as on the basis of that. And why is that? Because, I mean, fair or not, FHA loans, VA loans require they do require heightened scrutiny. They do require potentially repairs. VA loans, I mean, it's not a huge deal, but seller has paid for the pest inspection. So if you are subjecting a seller to additional requirements that they would not have been required to when they initially went under contract, that's a material change that does need to be disclosed. So make sure if you are changing your sources of funding, you're doing that. And I mean, also with, you've got all these increasing sources of funding, not only down payment assistance, but things like ribbon programs like that. I mean, those should also be disclosed as well. So, and generally your seller is going to know because they're going to be involved in the outset of that. But if you involve ribbon at a later stage of the process, obviously you're going to want to let the parties know about that as well.
So Nick, can I interrupt? I'm sorry, it's Annie
Yeah.
here. So with ribbon, since you just mentioned ribbon, a lot of times you're going in with a cash offer, and then in the ribbon addendum, it says that the buyer still has the right to secure their own financing, and a lot of buyers do that. Because it's in that addendum, are you cleared there, or should you still go ahead and put that in this contract somehow?
I would, so if you're using ribbon, so number one, if you use ribbon, they've already got that addendum in place. So that addendum to me is going to cover you. But if you decide that you're going to be using financing at a later point, then or if you're going to use that financing and you're going to bring that in, I would go ahead and disclose that on the contract. And you can use an agreement to amend the contract, or let us know and we'll do an addendum changing the financing for you.
Thank you.
Anybody else have any questions on that? All right. So we're going to move on to change number 8, another very substantial thing on your end. This has to do with your 14-day delay period. It is no longer a 14-day delay period. It's a 7-day delay period. And it also strengthens the language of basically why a party wouldn't be able to complete closing. So this is located on paragraph 12. Number 1, you are changing from 14 days. Your sellers, your buyers no longer have 14 days to delay your contract. They now only have 7. And it used to say if your buyer was unable to close, now it says if your buyer is not possible to close. That is used to strengthen the language, basically saying that if your buyer is unable to close, that could mean anything. They're just saying, well, I'm not able to get out of bed. Now, not possible is supposed to mean it to say there's no way that your buyer's gonna be able to close. So it's intended, or your seller's gonna be able to close. It's intended to put more power behind that language. So, I mean, realistically, situations where, like, let's say somebody is incapable of moving out of their house, or has decided not to move all their belongings in their house, saying, well, I really have 14 days to get these things out of my house. No, that's not what that delay period is for. You're still supposed to be operating in good faith. And obviously things happen. And if something happens, I think everybody would be sympathetic to that. But I think a lot of other things we're seeing, and I'm sure y'all are seeing this as well, is we're seeing contracts with unrealistic closing dates, consistent delays. Basically, in this market, I know that you have to be competitive. And so people are offering 2-week closes, knowing that they're just going to invoke that 14-day delay period, knowing that a lot of folks don't really challenge that 14-day delay period. So suddenly your 2-week close turns into a 4-week close. And that was what was intended all along. And so this at least cuts into that by half. So you're not seeing those 14-day delay periods. I mean, and we're seeing it a lot right now, very consistent delays, because I know a lot of you are probably having trouble getting your appraisals. Appraisals back in time, I've seen numerous closings delayed over probably past 3 months because appraisals have just been, they're given the nature of the market, appraisals just kind of been a little slower getting back. And so that is something that everyone's going to have to get used to, is changing that delay period from 14 days to 7 days, and therefore using a more realistic time frame when you submit your offer. And I know it's going to be difficult because you want to be competitive, but you also want to be realistic. Make sure you're in contact with your buyer's lender when you're determining that close date. Any questions about that piece? All right. It's change number 9, and I like this one. This is paragraph 23. This is a brand new paragraph. It is called the remedies section. And what it does is, it used to be that all the remedies for a breach were listed kind of spread out all throughout the document. Now it's all put on this one page, page 13. And it basically lists if the buyer breaches, then what the seller can get. If the seller breaches, how the buyer can benefit, who's responsible for attorney's fees, and it all lists it in one place. So that's going to make your life easier. It says no, will make life easier. That's obviously a typo. It's going to make everyone's life easier because if they have a question about it, you don't have to go digging through the contract. You just know to go to the end of the contract. And if someone says, well, if the buyer isn't able to close, or if the buyer does something to breach the contract, what's going to happen? Now it's all listed in this one section, so you won't have to go searching for it. So I'm glad that they did that. That's going to be really helpful for everybody. All right. And change number 10. Every year it seems to get longer, and it got longer again this year. So now the contract is 16 pages. Page 16 is now page 6. Page 15 is now page 16. So what's that going to do to you? You'll ask for page 16, and someone will be confused and correct you. Nope, it's page 16 now. Just that's the EMD receipt. So that's kind of is what it is. That's where we're at. And then I've got a couple little bonuses here for you. So your bonus change goes over the agreement to amend. The changes on that I think is important because this is probably a document that y'all are using a lot. And so on the agreement to amend, there are a couple changes. Again, big thing, it clearly clarifies on that if you don't check that little box under the delay period, then it's 7 days from the date that you put on the agreement to amend. If you check that box, it takes it from 7 down to 4. That's the only change there. That's the only change there. So instead of 14 or 4, it's from 7 down to 4. Not much of a difference. I mean, there is a difference between the two, but I mean, it's obviously much less than 14 to 4. So that's going to be helpful too, because it's going to kind of limit the frustration for those who don't understand the 14 days from the date that you put in the delay in the new closing date, as opposed to that needs to be the closing date. So it clarifies that a little more, so that's good. Also, it adds an amendment for home warranty. So if you decide at some point later in the transaction that a seller wants to provide a home warranty or doesn't want to provide a home warranty, you can make that change as well. So it should make things easier for you, and hopefully it does, but we won't know until we kind of get into how that's going to function. And just because, are there any questions about that piece? Okay. And just because I like y'all, I've got a second bonus change for you. I'm sure you've already had the opportunity to look at the new Working with Real Estate Agents form. That is the 2-pager instead of that brochure, instead of that website you click. You're now required as of July 1st to use that new form once you are working with, once you're interacting with your clients. The brochure was clumsy. Obviously the Working with Real Estate Agents form is for your protection. Just make sure to print them out, carry some in your car, carry some in your office, wherever you're going to go. Make sure you have it. I've included a link here in case you need that. So, but you should already have the opportunity to access and print that off. But if for whatever reason you don't have access to it, you're not aware of it, it really clarifies things a lot better. And it's going to make things a lot easier for you as agents to say, hey, if you're at some sort of function and someone starts talking about real estate and say, hey, I'd like to work with you. Give me 1 second, go to your car, get one of these, have them sign it. Really kind of awkward, but that's all right. It is what it is. I mean, sometimes that's the nature of the beast. And that's all I got. I know I've given you all a lot of information. Does anybody have any questions about anything that I've gone over? I know it's a lot. So if you don't want to ask them here, you don't have to. I mean, obviously contact me offline or something like that.
Nick, I have another question. Sorry.
Yeah, sure.
My question has to do with that new paragraph that's been added with the release of earnest money and all of that stuff.
Yeah.
Is that still like currently in order to get that earnest money, unless they sign to release it over, you have to pursue them in court?
Yep.
So does this paragraph
doesn't change that? Yeah, that doesn't change that. You still, Yeah, if you've got if you've got a party who disagrees as to the disposition of the earnest money, we as the escrow agent have to act as a neutral party with respect to that money. And therefore we can't make the decision as to the seller's right, the buyer's right. We have to say, hey, I'm sorry, if y'all have a dispute, even if one party's grounds for the dispute are some of the most ridiculous things that you've ever seen, we're still required to hold that money and send it to the clerk of court. Or alternatively, your buyer can file suit and get it that way.
Gotcha. Thank you.
And Doreen, I see your question on the chat that you only use one sheet of the working with real estate agents. Yeah, if you use you can use just the one for the buyer and same for the seller. What I usually suggest is if you can, just make it a double-sided copy. And that way, if you're using that way, you can kind of cut down on your costs, number one. Number two, you'll always have access to both sides of the paper when depending on who you're working with. And obviously, if you're working as a dual agent, then you'll handle it that way.
Do we have to give the brochure and that page, that 2-page thing?
Now, this is intended to replace the brochure.
Oh, okay, good. Thank you.
Yep. So yeah, this is what you use now. Hopefully you can get rid of that brochure and not have to fool with those anymore, or get rid of the ones you have. But according to the commission, you are supposed to be using this new one as of July 1st. Does anybody have any other questions about any of the information that we've gone through? All right, well, in that being the case, I'm going to go ahead and click on to, here's my contact information. If you want to request a copy of either the slideshow or I can send you a copy of this presentation, I am happy to do that. Just shoot me an email or give me a call, whatever you need to. You've got our address here at the office in Kannapolis. I've also included my Concord office because those are the two places that I am primarily at. And if anybody has any questions about anything, I'm generally pretty available. I think everyone can, anyone that I've worked with on and to any extent can tell you that I'm pretty easily reached and available for pretty communicative. But if anybody has any questions, just let me know. And so I really appreciate the participation today. I appreciate y'all all jumping on with me and learning about this. It is a big deal. And yeah, I look forward to seeing you all soon. Y'all have a great rest of your day. Thank you for coming. That's what that says.